Generally, in a product's liability action based on failure to provide adequate warnings, a plaintiff must prove that the lack of an adequate warning was the proximate cause of his or her injury. But what if the plaintiff failed to read the warning? Does this bar recovery? A federal district court in Pennsylvania considered this question in Nowak versus Faberge U.S.A. Faberge U.S.A. was a personal care products company that manufactured Aqua Net hairspray. Initially, the hairspray contained a nonflammable fluorocarbon propellant. However, the propellant was later discontinued because it caused environmental problems, and hydrocarbons, butane and propane, which are flammable, were substituted. Following the substitution, Faberge didn't change the warning label on its product despite reports and complaints of injuries caused by puncturing the hairspray cans near an open flame. In April of 1989, Allison Nowak attempted to remove the top of a non-functioning can of Aqua Net hairspray with a can opener and pour the can's contents into a pump bottle. But as she attempted to remove the top, she punctured the side of the can and the spray spurted out. The spray reached an open flame on a nearby stove, engulfing her in flames and causing burns on her body. A printed warning on the back of the hairspray can read that the product was flammable and that the user shouldn't use the product near fire or a flame or while smoking. Notably, however, the warning was smaller than other words on the front and back of the can. Subsequently, Nowak sued Faberge in federal district court, alleging that it failed to provide adequate warnings regarding the dangers posed by the hairspray can. At trial, Nowak called an expert witness who testified that the warning label provided on the can was defective and inadequate. Nowak also called a second expert who testified that a better warning might have made a difference and that the defective warning was a significant factor in causing Nowak's injuries. Further, Nowak testified that she didn't read the warning label on the back of the can because it was in small print and she didn't think it was important. However, she claimed that had the warning been on the top of the can and in larger print, she would have noticed it and read it. Following trial, the jury returned a verdict for Nowak on her failure to warn theory. Faberge then filed post-trial motions for judgment notwithstanding the verdict, or JNOV, and a new trial.